Today, we are going to talk about judicial responses towards promotion and protection of women's rights. The Indian judiciary has completed 66 years of its existence and has made long-lasting contribution to the system of governance that has impacted the life of the people and the nation. In many ways, it has impacted the nature, scope, and processes of public governance and can claim credit for expanding the meaning of the Constitution in favor of different segments, especially the poor and the women of society. It has strengthened Indian federation, catalyzed goal achievement, deepened democracy, and defended people against excesses of the state. It has acted as a promoter of peace, cordiality, and balance and coordination between different organs of the government. At one time, it was thought that the role of judiciary is only to interpret the laws and the regulations and provide judgments exclusively from the legal point of view. This perspective has undergone a sea change in the recent times. It is true that courts are the true protectors of rights and freedoms of citizens and individuals. The Constitution of India empowers particularly the Supreme Court and the High Courts to promote and protect the vulnerable sections of our society. These constitutional courts can enforce the provisions of the Constitution and the relevant statute laws. Responding to the role expectations, the Supreme Court has given both a technical and expansive interpretation of the fundamental rights and has issued various directions and guidelines to uphold human dignity and human rights of the people of India and more so of the weaker sections such as women, children, bonded labor, scheduled caste, scheduled tribes, other socially and educationally backward classes. The courts have been sensitive to the changing socio-cultural and politico-economic milieu of the country. The growing public support to the activist role of the judiciary has further strengthened the position of preeminence that the judiciary has come to occupy among the three organs of the government. It has, unlike the past, been entertaining a number of petitions which involve, apart from legal issues that relate to the administration, governance, and policy. Therefore, judiciary has not only been playing as a social auditor, but also very meaningfully acting as a social, political, cultural, and economic auditor. Since the Constitution of India is the law of the land, it has become the legitimate source of the court to uphold the Constitution and rule of law in the country. The Constitution has undoubtedly given the mandate to the court to promote and protect human rights of citizens and individuals. Hence, the court plays a vital role in maintaining a constitutional governance in the states. The Constitution of India not only grants equality to women but also empowers the state to adopt measures of positive discrimination in favor of women for neutralizing the cumulative socio-economic, education and political disadvantages faced by them. Fundamental rights, among others, ensures equality before the law and equal protection of law, prohibits discrimination against any citizen on grounds of religion, race, caste, sex or place of birth, and guarantee equality of opportunity to all citizens in matters relating to employment. Articles 14, 15, 15 Clause 3, 16, 39 Clause A, 39 Clause B, 39 Clause C and 42 of the Constitution are of specific importance in this regard, especially for promotion and protection of women's rights, in which judicial responses are also found to be proactive. The advancement of women has been a focus of the work of the United Nations since its creation. The preamble of the Charter of the United Nations sets as a basic goal to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women. Furthermore, Article 1 of the Charter proclaims that one of the purposes of the United Nations is to achieve international cooperation in promoting and encouraging respect for human rights and fundamental freedoms for the people without distinction as to race, sex, language or religion. As early as in 1946, the Commission on the Status of Women was established to deal with women's issues. The Universal Declaration of Human Rights has affirmed the principle of the inadmissibility of discrimination and proclaimed that all human beings are born free and equal in dignity and rights, and that everyone is entitled to all rights and freedoms set forth therein, without distinction of any kind, including distinction based on sex. However, there continues to exist considerable discrimination against women because women and girls face a multitude of constraints imposed by society, not by law. It violates the principle of equality of rights and respect for human rights. The General Assembly on November 7, 1957 adopted a declaration on the elimination of discrimination against women, and in order to implement the principle set forth in the declaration, a convention on the elimination of all forms of discrimination against women was adopted by the General Assembly on December 18, 1979. The convention is often described as an international bill of rights for women which came into force in 1981. Although the International Bill of Human Rights laid down a comprehensive set of rights to which all persons, including women, are entitled, additional means of protecting the human rights of women were seen as necessary because of the fact that humanity has not been sufficient to guarantee the protection of rights of women. The preamble to the Convention on Elimination against Women explains that despite the existence of other instruments, women still do not have equal rights with men. discrimination against women continues to exist in every society. Article 1 of the Convention on Elimination of Discrimination Against Women defines the term discrimination against women as any distinction, exclusion, or restriction made on the basis of sex which has the effective purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of man and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. India has ratified the Convention on the Elimination of All Forms of Discrimination Against Women on 9th of July 1993. Ratification of the Convention obliges India to honor the obligations imposed by the Convention. The apex judiciary in India has interpreted a number of basic human rights of women in the light of fundamental rights guaranteed in Part 3 of the Constitution. These fundamental rights have gone much beyond the American Bill of Rights. Judiciary in India has retreated the human rights of women by filling the vacuum in municipal law by applying, wherever necessary, international instruments governing human rights. In a series of cases, the apex judiciary has set some remarkable standard of asserting the gender equality and human rights of women. In a historic judgment, Sarla Mudgal versus Union of India, 2002, ALD CRI 686, the court held that the second marriage of Hindu after his conversion to Islam was void in terms of section 494 of IPC, and the husband was liable to be prosecuted for bigamy. In Air India versus Nargesh Mirza, AIR 1981, Supreme Court 1979, page 1868, the validity of the Indian Airlines and Air India's service rules providing that an air hostess had to retire from service at the age of 35 or on marriage, whichever was earlier, or if she got married within 4 years of confirmation or on first pregnancy, was struck down and held to be arbitrary. A judgment delivered in State of Punjab versus Gurmeet Singh, 1996, AIR, page 1393, 1996, SCC 2 384, the Honorable Supreme Court, while convicting 3 rapists of a minor girl, has directed that all such trials must be held in camera. In Air India Statutory Corporation versus United Labour Union, AIR 1989, Supreme Court, page 1185, the Supreme Court has held that it is the duty of the state to take responsibility for further development of these human rights and fundamental freedoms. In Pragati Verghese versus Cyril George Verghese, AIR 1999, Kerala 345, The full bench of the Bombay High Court has struck down Section 10 of the Indian Divorce Act 18, under which a Christian wife had to prove adultery along with cruelty or desertion while seeking a divorce on the ground that it violates the fundamental rights of a Christian woman to live with human dignity under Article 21 of the Constitution. In another significant judgment in Nur Sabah Khatun versus Muhammad Qasim 2003 JKJ 184, the court observed that we have opted for a secular republic. Secularism under the law means that the state does not owe loyalty to any particular religion and there is no state religion. The Calcutta High Court has extended the iddat period till such time the woman remarries to allow Muslim women a maintenance allowance beyond the customary iddat period of about 3.5 months under the Muslim Women Protection on Divorce Act 1986. After all the discussions we had, we can finally conclude that it can be observed that not only the legislature but judiciary also plays a very vital role in promoting and protecting women's rights. Judiciary empowers the women by its both traditional and by its activist role. The traditional role of judiciary is to provide justice through interpretation of laws, sometimes through the wide interpretation of provision of various legislations, national as well as international, and also the provisions of constitution. Judiciary is able to empower the women. Now, women empowerment is a burning issue of our country, and this concept is in progress. So there are so many areas of women empowerment where there is no law for the protection of women. In that case, judiciary is the last hope, because judiciary can only give justice by applying its activist power. So it is clear that through judicial activism, judiciary is also able to provide progress in the area of women empowerment by promoting and protecting women's rights and dignity.